Your mother dies on a Tuesday in March. 6 weeks later, you are sitting in a small office in the main street, and a solicitor slides a folder across the desk and tells you the house is yours. 3 bedrooms in Bendigo, paid off since 2009, worth about $900,000 on today's market. No mortgage, no debt, nothing owing against it to anybody. Nobody in that room mentions that a clock has already been running for 6 weeks and that it started on the day she died. Not the day probate came through. Not the day the title changed hands into your name. The day of death itself. So you are already 6 weeks into a 2-year window before anybody in that office says the word deadline out loud. What you do inside that window decides whether this house costs you nothing at all or costs you $70,000. Same house, same sale price, same family, sitting around the same table. The entire difference comes down to timing and to one paragraph in your mother's will that nobody has read carefully yet. Start with what did not happen, because it sets up everything else. Inheriting the property was not a tax event. Receiving the property did not trigger capital gains tax, and no bill arrives in the mail. Nothing at all happens on the tax side the day the title changes hands. The tax point arrives much later, at the moment you dispose of it. That is the first thing people get wrong. People brace themselves for a bill that was never coming, then relax at precisely the moment they should be paying the closest attention of the whole process. Now, here is the rule that matters more than anything else in this video, and it is genuinely generous. Most families never find out it exists until well after it has already lapsed on them. If the house was your mother's main residence immediately before she died, and it was not producing rental income at that point, you can sell it completely free of capital gains tax within 2 years of the date of her death. 0. Not reduced, not discounted, not deferred to a later year. If the place appreciated $700,000 over the 30 years she owned it, none of that growth is taxed. It also makes absolutely no difference whether you moved in during those 2 years, rented it out, or left it standing empty with the power disconnected. There is one detail buried inside that rule which catches people constantly though. It is not the contract date that counts. Settlement has to fully complete inside the 24 months, and settlement is the part of a property sale you control the least. So a contract, signed at 23 months, with a 90-day settlement attached to it, lands outside the window. On paper, and to everyone involved, the sale looks like it happened comfortably in time. As far as the exemption is concerned, it did not, and there is no partial credit for having come close. It is a completely binary outcome. Now, step past the 2-year mark and watch what changes. You held on to the house, which is what the majority of Australian families actually end up doing. Perhaps your sister was living there. Perhaps the estate took 18 months to untangle. Perhaps you simply could not face clearing out a bedroom that still smells like her. All 3 of those are completely normal, and the tax code treats none of them as a reason. Once the window closes, the cost base becomes the market value at the date of death. $900,000 in your case. And that number matters more than people realize. That reset is enormously valuable, and it is worth pausing on for a moment. Your mother bought that house for $160,000 in 1994. Every dollar of growth between that purchase and her death is wiped out for tax purposes. $740,000 of capital growth, erased from the calculation entirely, and you never have to account for a cent of it. But everything after her death is now yours to account for. So sell at $1.1 million, and the taxable gain is $200,000, rather than the $940,000 the house actually grew by since she signed for it. Hold it more than 12 months, and the 50% discount applies. Therefore, you are taxed on $100,000. At a marginal rate of 37%, that comes to $37,000. $200,000 of gain, and roughly a third of it gone. All because settlement landed on day 731 instead of day 729. And here is where I need to stop and deal with something directly, because a reasonable person watching this is already thinking it. You are thinking, I would simply move in, live there myself, make it my main residence, and the exemption follows me across. That was true for a very long time. Thousands of Australian families have written wills and made plans around exactly that assumption, and their solicitors told them at the time that it would hold up. In March this year, the Australian Taxation Office released a draft determination called TD 2026/D1. It quietly changed the answer. and almost nobody outside the accounting and legal professions has heard of it yet. The determination draws a line between two things that look completely identical from a kitchen table. On one side sits a right to occupy the house, granted expressly by the will itself, in writing. On the other, a right that exists only because a trustee decided to allow it. If your mother's will created a testamentary trust and gave the trustee discretion over who could live there, then the ATO's draft position is that discretionary permission does not amount to a right to occupy the dwelling under the will. Therefore, the main residence exemption does not apply for that period of occupation, no matter who was actually living in the house or for how long. There is a published example showing exactly what that costs a family. A $300,000 gain that would have been entirely exempt under the previous reading becomes fully taxable. After the 50% discount, that produces a bill of $70,000 or more, depending entirely on the beneficiary's marginal tax rate that year. Nothing about the house itself changed. Nobody moved in or out. Not a single brick of it was touched. The only thing that moved was the ATO's interpretation of what the will needed to say. And in that example, the will did not say it clearly enough. Commentators in the financial press have been calling it a death tax by stealth. It is still a draft, therefore the final position may well shift before it is settled. But if you are administering an estate right now, this is the first question to put to a solicitor, ahead of every other question on the list, including what the place is worth. There is one more cost running underneath all of this, the entire time, and it has nothing whatsoever to do with capital gains tax. For every single day you hold that house without living in it, Centrelink counts it against you. The home you live in yourself is exempt from the assets test. An inherited property that you are not living in is not exempt at all. It is an assessable asset, counted at its full market value from the moment it becomes legally yours. $900,000 of assessable assets puts a single homeowner well past the cutoff point of $733,500. So if you were receiving an age pension, it stops. Not reduces. Stops completely, along with the card that comes attached to it. Which means that 2-year window is not only a tax deadline sitting quietly in the background. For a pensioner, every month you spend holding that house can cost the full pension and the pensioner concession card simultaneously. None of that is backdated or repaid to you once the house finally sells. One piece of relief worth knowing. The ATO can extend the 2 years where the delay was genuinely outside your control. Legal disputes over the will qualify. Serious difficulty obtaining probate qualifies as well. Family indecision about whether anybody wants to keep it does not. So the honest summary is this. Inheriting a paid-off home in Australia hands you a genuinely generous exemption, with a very specific deadline attached to it that nobody is obliged to remind you about. Sell inside 2 years from the date of death, with settlement fully complete, and the tax on all that growth is nothing at all. Miss it, and 3 things happen at once. You are taxed on the growth from the date of death. You may lose the exemption altogether depending on how carefully the will was drafted. And you may have been off the pension for the entire period you spent deciding. Tell me in the comments whether anybody in your family has ever actually read the occupation clause in their will, or whether it is one of those documents that gets signed and filed and never opened again.